To begin with, I want to thank everyone, of course, for coming today. I'm Dr. Ntina Tzouvala, and I'm the convener and organizer of this seminar series entitled The Politics of International Law that takes place under the auspices of the Center of International and Public Law here at the ANU College of Law. And before we get started, I would like to acknowledge that I find myself today on the unceded country of the Nawagal and Ngambri people, and I want to pay my respects to elders past, present, and emerging, as well as any Indigenous people who might be joining us tonight. And I want to acknowledge that sovereignty over these lands has never been lawfully ceded. Today, I'm very excited to be bringing in conversation two powerhouses of international law. Our main speaker today is Dr. Martins Paparinskis, who is a reader in public international law at the University College London. Martins is a generalist public international lawyer who also has a broad and interesting range of specialist interests, including state responsibility, dispute settlement, and international investment law, as well as international human rights law. His work has appeared in some of the leading journals of the discipline, including the American Journal of International Law, the British Yearbook of International Law, the European Journal of International Law, and relevant to tonight, the Modern Law Review. And his work has been cited extensively by domestic and international courts and tribunals. And also, and we wish him all luck, he's currently running as the candidate of, a joint candidate of all Baltic states, sorry, I'm trying to adopt him, Baltic states for the International Law Commission, no less. And I hear that actually common nominations are not a very common thing amongst the Baltic states. So it says a lot about the recognition and respect his work commands. And tonight, Dr. Paparinskis will be speaking about making a case against crippling conversation in international law based on a piece of his that was actually published in the Modern Law Review roughly a year ago. In conversation with Dr. Paparinskis, we have Professor Anthea Roberts, who is a professor here at the ANU at the School of Regulation and Global Governance. Professor Roberts is also a public international law specialist with an interest also in international investment and economic law. So you can see there the intersections. She's also interested in comparative international law and on the influence of geopolitical shifts on international law. And in fact, recently her work has been focusing increasingly on geonomics and international law. And in 2020, she taught as a visiting professor a course on geonomics at Harvard Law School. She's the author of course, Is International Law International? And also she's the co-author, along with Professor Nicholas Lamb, of the forthcoming 6 Phases of Globalization, which will be coming out with Harvard University Press later this year. So without further ado, I'm going to give the floor to Dr. Paparinskis, who will be speaking for roughly 30 minutes, followed by a Q&A with Professor Roberts for roughly 15 minutes, and then we will conclude with questions from the audience. It will be really useful if you're in the audience and you want to ask this question, to start sending in these questions as you think of them and not wait towards the last minute, because this will help us to speed up the process. So Dr. Paparinskis, thank you very much for joining us. The floor is yours.
On 8th of March 2019, an international arbitral tribunal constituted under a bilateral investment treaty rendered an award in the case ConocoPhillips and Venezuela, requiring Venezuela to pay compensation of around $8.7 billion. On the same day, Venezuela was hit by a major blackout that continued for almost a week. One day before, the International Monetary Fund describing Venezuela as, I quote, facing one of the most complex situations that we have seen here at the fund. And that is a combination of food and nutrition crises, hyperinflation, destabilized exchange rate, very debilitating human capital and physical productive capacity, and a very complicated debt situation, end of quote. The IMF had earlier projected a 5% fall of gross domestic product at a 10 million % inflation rate for Venezuela in 2019. The ConocoPhillips Tribunal had already established its jurisdiction and Venezuela's responsibility. Therefore, the award's 1,110 paragraphs over 331 pages were devoted only to compensation and valuation. The highly sophisticated council and the tribunal engaged in considerable detail with these issues, without, however, attributing any legal relevance to the economic and political crisis facing Venezuela. So I start a little bit pretentiously with quoting from the first paragraph from my article in the Modern Law Review of November that Dina very kindly mentioned in her introduction. Let me just say how very grateful and privileged I am to have been invited to many wonderful friends at ANU, and the series is really a powerhouse exposition of fantastic scholarship. So, so very honored to be here. The question is, what does the law state responsibility tell us about such situations? Now, I imagine that in the story, normative instincts of many of the listeners will be inclining in one way. So let me complicate the story and add two more hypotheticals, both coming from last Thursday and confirming my firm view that the predictor about developments of international law are firmly arranged around my academic schedule. The world happens because I have to teach about it. Last Thursday morning at 11:30 a.m. at the Peace Palace, International Court of Justice, President Donoghue presiding, Uganda opened its pleadings in the case concerning armed activities on the territory of the Congo case, reparation stage. And Honorable William Byaruhanga, agent of Uganda, made the opening observations. In paragraph 24 of these observations, he made the following point. Finally, the staggering amount the DRC claims is fraught with ruinous economic consequences. Compensation must neither exceed the payment capacity of the responsible state nor deprive the people of the responsible state of their means of subsistence. And then he says a little bit on the lawyerly things and concludes in paragraph 28, ordering Uganda to pay the approximately 13.5 billion the DRC seeks would mean that about twice Uganda's consolidated annual public spending would need to be transferred to the DRC. The toll on the well-being of the Ugandan people would be enormous. It would also compromise the programs that Uganda has been conducting to promote peace and stability in the whole of the Great Lakes region, end of quote. So here we have a very different dispute settlement setting, interstate dispute settlement, where we take as a given they already determined by res judicata in the previous stage fairly significant breaches of international law, including rules on the use of force, as well as multiple rules on IHL. So perhaps normative intuitions are a bit more mixed than for ConocoPhillips. Let me now suggest a case where I would imagine an academic audience, the normative intuitions will be entirely one way. And that is a decision by the president of the InterAmerican Court of Human Rights, President Elizabeth Odio Beneto, of last Thursday in Casa Profesores de General y Otras Municipalidades versus Chile, a case opposing Chilean academics claiming their very long overdue salaries promised for decades from Chile. I wonder where academics would find equities in that case. And among other things, in paragraph 46, the Inter-American Court confirms the appointment of an expert, and I quote, quien declarara sobre las medidas de reparación en el derecho internacional público, incluyendo el caso de reparaciones incapacitantes. So again, a question about excessive compensation. ConocoPhillips and Venezuela, Congo and Uganda, the professors of Chañaral and other municipalities against Chile. Analytically speaking, for purposes of public international law, all of these cases may be located in the same legal space. As we know, public international law is an advanced and elegant legal order for the purpose of state responsibility. We conceptualize all breaches of primary obligations, whatever their content, giving rise to a singular body of secondary rules. Now, there are some qualifications around the edges, but the gist of the argument is there. I want to make 3 points in relation to this puzzle. And the puzzle is, I think, the one that was really implicit in all these examples. Is it a legally relevant consideration for determination of quantum of compensation, the effect that it may have on the responsible state and its peoples? And I want to make 3 points here. I will first do a deep dive into the International Law Commission's work throughout the 1990s, culminating, of course, under the leadership of Judge Crawford in the 2001 International Law Commission's Articles on Responsibility of States for Internationally Wrongful Acts. Then I will have a look at what has happened in the Alexander Dumas spirit in the last 20 years after that. So, Musketeers may have been there, but after that, some things happened as well. So those would be mostly formalist arguments. And then I will say some perhaps lightly normative things, at least, about the directions to the future. So what do the 2001 ILC articles tell us? And of course, with all due appreciation, they're not formal sources of law. At the same time, very authoritative subsidiary means for determination of rules of law. So the whole David Caron theme, they are very authoritative, wonderfully, elegantly and sharply drafted, and plainly exercise a great deal of influence in the international legal process. So whether one fully agrees or disagrees with them, they are worth taking, at least as a very serious starting point. And to the extent that we sort of flick through every 3 years through the Secretary General's prepared compilations of tribunal practice that have invoked 2001 ILC articles, they really are seeping extremely deeply and routinely in state and judicial practice. Those who challenge 2001 articles almost invariably fail. So what do the articles tell us? And here, just sort of very briefly reminding ourselves, I'm sure that you know all these things much better than I do, but just so that we're on the same page, the 2001 articles are composed, as many things in life, of 3 parts. Part 1 tells us about internationally wrongful act as the generating factor of state responsibility and speaks about attribution, breach, and circumstance precluding wrongfulness. Part 2 speaks about content of international responsibility, as it were, consequences. You're wrongful, so what? What needs to be done to address it? And Part 3 speaks about invocation implementation. So is there an issue? So what? What to do about it? And questions of compensation are situated within Part 2. They are part of the content of reparation. There are 3 forms of reparation. I think that's fairly widely accepted as reflecting customary law, most recently in the Enrica Lexi arbitral award. And the 3 forms of reparation are restitution, compensation and satisfaction. And I apologize, I'll just do a little bit of extremely light textual quoting, so just to contextualize where ILC ended up with. What are the limits set for these forms of reparation? And here we see a little bit of an outlier. When we look at Article 35 and restitution, we see that restitution cannot, and I quote, involve a burden out of all proportion to the benefit deriving from restitution instead of compensation, end of quote. So no disproportionality. And when we flick two provisions further to Article 37 on satisfaction, we see in paragraph 3 a statement that, and I quote, satisfaction shall not be out of proportion to the injury, end of quote. But when we go to Article 36, the one on compensation, we see nothing of the sort. The state is responsible to compensate for the damage caused thereby. So there's a bit of causality, but certainly we do not have anything on this proportionality of the sort that we just saw. Now, is that an accident? And if we flick through the commentaries, we see that it is not. In commentary 5 to Article 34, that sets out forms of reparation, the ILC essentially says very honestly and openly, and I quote, concerns have sometimes been expressed that the principle of full reparation may lead to disproportionate and even crippling requirements so far as a responsible state is concerned. But, says the ILC, this is how we do it for restitution, this is how we do it for satisfaction, while compensation, says the Commission, is limited to damage actually suffered as a result of the internationally wrongful act and excludes damage which is indirect or remote. So it does not exclude damage which is excessive. That is the position of the International Law Commission. The effects on the responsible actor are irrelevant as long as they are linked by causality to the loss. So how did the International Law Commission end up in this place, sort of, you know, the record scratch type of intellectual perspective? This is me. You may be wondering how I ended up in this place. And there are three very interesting things that took place in the ILC through the 1990s. So that is sort of the late reports of the penultimate special rapporteur, Gaetano Arancio Ruiz, who starts dealing with content and compensation. So the first installment comes in 1990. And in that setting, the ILC is explicitly discussing effects of excessive compensation. We have, in a prequel sort of mode, two future judges, including one future president of the International Court of Justice, being not very impressed by it. So the first person to speak on the topic is Judge Shi, future president of the International Court of Justice, and he has really a wonderful sort of intervention. He starts off by saying something about satisfaction. He has really a quote that I think our chair might appreciate, or perhaps might not appreciate, by saying that, quote, one could not expect legal scholars nurtured in the Western tradition to have a full understanding of the history of the Chinese revolutionary movement, end of quote. And then there is some discussion of the humiliating satisfaction imposed as part of response to what Arancio Ruiz had described as a Boxer rebellion, to which Judge Shi took an exception. But as part of that broader theme, he also challenged compensation. And Judge Shi is was very much seeped in the scholarship of the new international economic legal order. So if we look at the 1980s and Chinese Yearbook of International Law, that is where he was coming from. The second person to speak on the topic even more extensively was Judge Benuna, who was also coming so very much from the new international economic law perspective, going back to his scholarship in Revue juridique politique et économique du Maroc of late 1970s, and more recently with Bejawi. So we're both challenging and saying, look, we can imagine situations when there would be huge investment claims, including for lost profit. Plainly, it cannot be reflective of sovereign equality, that in such circumstances there would be no effect given to the perspective of the responsible actor. And Arangiorou is so again, I simplify. I think that he's sort of probably saying, well, you know, but nobody thought that it would. Of course, there would have to be some equity taken into account, and there's a sort of commentary included in the general rule in the first drafting on reparation, saying that equitable considerations may be taken into account, particularly when there is limited financial capacity for the responsible actors. The second line, so that is what happens in 1990. I think that there's sort of delightful whiff of, I suppose, if I can use such an awkward term, presentism. The assumptions that the normal operation of the international legal order is like it is at that point. And so in 1990, the normality is the background echo of the battles of the new international economic order. By 95 and 96, new international economic order is crushed to the extent that not even vague memories remain. So investment law is not mentioned at all. What is in the background in 1995-96, and again, the assumption that this is what international law will always be dealing with is on this issue, is the topic of war reparation claims and the United Nations Compensation Commission. And International Law Commission so builds on its 1990 discussion, even if from an entirely different angle. So it's interesting, the hypotheticals about normal operation of law. Now we are in the war reparation context, and there, importantly, United Nations Compensation Commission in its foundational instruments includes explicit limitations of certain percentage of oil proceeds that have to be left to Iraq and its people. So the intellectual assumption now is more that this is a thing that needs to be taken place, as it were, externally rather than internally. Not an equitable consideration within the valuation process, but the limitation on the final sum. And that is what the ILC puts in Article 42, paragraph 3 of the first reading, that there should be, shouldn't affect the means of subsistence of the responsible state. Now, that is where we get in 1996 when the articles are adopted in the first reading. Then we have the second reading and everything changes. And the fantastic thing about this is that we cannot really say that this is something that was not appreciated by the ILC drafters. The sharpest minds, including that of Judge Crawford, were directly addressed at the issue. So here we have to jump 5 years onwards in 2000. And so there, again, we are intellectually in that odd space that we know in retrospect was the sole moment probably for about 5 years in the last century when foreign investment law seemed like an uncontroversial thing. So new international economic order was already down and forgotten. Investment arbitration was rising. So in the middle, second reading was made. In the third report, Crawford looks at the first reading and finds it wanting. And he says, and sort of I'm here pulling together a number of threads from his report and submissions, but he essentially says that, look, this is a trivial challenge. Let's start with that. In courts and tribunals, we mostly have small claims. So he's looking at 2000. If we have big claims, well, first of all, it's less about law and it's more about not being stupid. And the contrast, so it's very Keynes' economic consequences of peace. If you do Versailles, you get Hitler. If you do Potsdam or San Francisco, you get democratic, developed Germany and Japan. So it's important not to be stupid about law. It's really something where we have to trust political wisdom. And after the Second World War, we did trust it. Finally, we can trust international institutions. Security Council creating the UNCC, UN Compensation Commission on Iraq, included these things explicitly. So this is all rather trivial, or can be addressed by circumstances precluding wrongfulness. And then there is quite a bit of state practice coming in, including, I think if I can just find the right file. I mean, essentially, there's a wonderful intervention in 1999 from the Australian representative who says, well, Australia is really unfamiliar with there have ever been any rule or to the effect or that reparation can be limited to the effects on peoples. It's unclear, it's not established, it's going to be abused. And UK, US, France, Japan and Israel are coming in a similar way. So there's a sort of a lot of practice in that regard. So that is what happened then, and in 2001, this is a rule included. Quite consciously, the effects have been rejected. Now, I have probably about sort of 5-ish minutes, so let me just make my 2 remaining points. The first is, what happened to the gang after 2001? And here, I think, as I outlined, I hope fairly, Crawford's and ILC's assumptions, I think that probably we'll find them less persuasive nowadays. Large claims are brought in an interstate setting. You saw just last Thursday, Congo and Uganda. We had a fairly significant claim as well in Ethiopia, Eritrea Claims Commission. Also, and importantly, we have a new ruthless actor in the international legal order, non-state actor, that does not have the repeat playing incentive to be egoistically enlightened and not to destroy the system. A human rights or an investment claimant does not majorly care about it. Whether they are in one setting or another, they want to win the case and vindicate their interests. So these things are unlikely to work in a systemic sense as Crawford and the ILC intended. At the same time, for legal purposes, it does seem to me that the solution has been broadly endorsed. It has come up in a number of settings. It came up in the ILC when the ILC returned to the analogous topic for responsibility of international organizations. And there, the question sort of arose as a background assumption. But nobody argued that the ILC had got it wrong. Even international organizations, including the World Health Organization, who said, well, we wouldn't really like anybody to make claims against us. We don't really have financial capacity. We're rather trying to distinguish themselves from states. They were saying, well, states, of course, they have taxation rights. We don't have that. So the normal rule for states does not apply. Even more importantly, states haven't really invoked it as a defensive argument in cases. And this seems to me like a meaningful silence within the sense of conclusion 10.3 of the 2018 ILC conclusions on customary law. The sort of idea that if an actor is faced by a multi-billion claim, one might expect that to focus their mind. And if they are not saying that there is a limiting principle that saves me, it is suggestive of, I suppose, an opinion non juris, a sense that the argument is so trivial, so bad, that we will not even raise it, so as not to make us look ridiculous more generally. So I think as a more general matter, it seems to me that in various settings, except Congo, Uganda, which is a little bit of an outlier, and happy to discuss it, how that changes the picture. Slightly annoyingly, the written pleadings, as you will know, are only released when the oral pleadings start. So it's only last week that we found out that in 2016 and 2018, Uganda had actually invoked that argument in the setting. So I think that says something about publicity and its effect on international lawmaking. But broadly speaking, I think that there is that tension. The assumptions of ILC are not necessarily persuasive nowadays, but the legal solution has been broadly endorsed by the process. So where do we go on from here? And slightly schematically, I think that we have three futures. The first future is the one that is most likely to happen, and that is the present. In line with the ILC, this is not a legally relevant consideration for determination of quantum. Every new failure to challenge it further endorses it. So this is what the Ninth Oppenheim says on this issue. If states can't pay, that is something that will have to be taken into account in arriving at a negotiated solution. So quantum is simply a number on the paper. Reasonable people will negotiate it. The second response is that this is an issue, but an issue that needs to be addressed on a case-by-case basis. So can we really come up with a general secondary rule that is simultaneously attuned to the equities of the professors of the Chanarayas and other municipalities, ConocoPhillips and Congo, Uganda? So these are answers that really need to be located at the level of particular primary rules, special secondary rules, or institutions for implementation of responsibility. And Crawford and indeed Arangio Ruiz are very comfortable with that. They're saying we are not saying that this is an irrelevant consideration as a general proposition. We are saying that it simply doesn't fit at the level of general secondary rules. And finally, it is also conceivable that custom could be changed on the issue. And I spend quite a bit of time in my article in explaining the pros and cons for that. I think I tried to be upfront about it, about the importance of generating new widespread, fairly consistent practice in bilateral and multilateral settings in various ways, and also of conceptualizing it in a way that, even though departing from the current law, it goes with the broader grain of current law. And if we conceptualize it, as I suggest, along the lines of rules within law of the maritime delimitation, or transboundary water law, of having a vague rule, a question that we ask about the topic and ability to identify relevant considerations, it's perfectly conceivable how such a rule could operate. Now, there would be very, very hard questions about the relevant considerations and how we balance it out in non-state actor state and interstate context and how we implement it. But I think that there is one somewhat comparable example, the principle on contribution to injury, coming from Article 39 of the ILC articles, inserted there, I feel, a little bit out of respect for some scholars who had written on it. And then it has really taken off to incredible effect in the last few years in the investment arbitration practice. And that is, that is how decentralized process works. Vague rules are ideally elaborated through a state and institutional practice. And that is certainly one way of thinking about it. And I think that this is the point that I was trying to make here, that it's possible to think of having this small added thing to international legal process, which ultimately, as in a formalist legal process, will have to we have to fall on whether that is something that is found useful by actors or not. Well, thank you very much, Dina, for having me, and I look forward to Anthea's comments. Thank you.
Thank you so much for this amazing presentation that I think raises both questions of legal doctrine, but also broader considerations. I'll pick up two, I think, don't be stupid about law. That was the one. And secondly, how important multi-billion claims can be to focus the legal mind. I think these are two good takeaways, but for the rest, I will give the floor to Anthea Roberts to start a conversation with Martins.
Thank you, and thank you for inviting me today. And Martins, it's also lovely to be on a panel with you again. I think the last time we saw each other was 7 or 8 years ago, so this is one of the advantages of the pandemic and Zoom. So thank you, Nina, for bringing us together. I wanted to not take this as an opportunity to give my own reflections, but I wanted to take it as an opportunity to engage you in the kind of questions that came to me when I was reading your paper. And I really like your paper, and I like it on a couple of different levels. But I thought it'd be helpful for me to kind of walk through the first bit of the paper that actually, a lot of the paper I completely agree with. So for example, the instinct that Crawford's assessment of the sort of lack of large claims has not aged well, I think is sort of irrefutable. And I think a lot of your logic is absolutely irrefutable. But I wanted to come back to something which comes up multiple times in the paper, where I think you and I might see it slightly differently or might have slightly different words for it. So I wanted to flesh that out, which is that quite often in the paper, and you didn't say this in the presentation, but quite often in the paper, you said really what's going on here is that the tribunals have a very bilateralist approach. So they have a very bilateralist approach, which means they just focus on the losses of the claimant. And they don't have a sort of a multilateralist or a communitarian approach. And this struck me as a really interesting way of framing it. And I thought if I were to frame it, I would actually frame it, I think that we have a similar instinct, but I would actually frame it differently. And there are sort of three parts to the difference of what I would frame. So let me step those out one at a time. So the first thing is I would actually describe the current approach not as bilateralist, but as unilateralist, because I think they focus not just on the case and the disputing parties, which is what you might think of as bilateral, but within that they focus just on one side, which is what has the loss been to the claimant, not what is the loss and what would the effect be vis-a-vis the claimant and vis-a-vis the respondent. And so my first instinct is I would call that unilateralist rather than bilateralist. Do you want to respond to that? Or and then I'll go to the second element of the critique of this. Martin,
I mean, I think it was a good question. I'm just sort of reflecting on whether I agree with the substance, whether this is a terminological or substantive difference. So it seems to me that I mean, I think that there is, to some extent, the rules on content of responsibility, and that is, I think, so there's two perhaps of slightly bigger discussions to which I was trying to contribute, as you say, so perhaps around the lightly normative edges, is one of the bigger tension in international law between bilateralism and multilateralism, playing out differently in different settings, but of course very familiar for state responsibility, particularly on invocation and aggravated responsibility and consequences. And the other one is perhaps cautiously, without making any big normative assumptions, is analogy with the domestic tort law debate, which perhaps in some sort of the more traditional mainstream readings would be describing it as focused just on correcting the loss, corrective justice approach, bracketing out everything that is outside the particular bilateral relationship. And it seems to me that to some extent, there may be some aspects where the responsible actor is relevant, but it's still within the four corners of the bilateralist relationship, sort of the contribution, mitigation, causality, concurrent conduct, overdetermination.
So
I don't think that you,
Yeah. So let me explain my steps 2 and 3, because I think they will help you see whether this is just terminological or not. So I think that first step is actually just terminological. I think we're saying the same thing, but we're calling it something different. But I think that it becomes important as we go through, because I think your instinct is you want to touch to these broader debates, but I think we might be able to get there in a sequence. So the first thing I would say is, I think it's taking the dual relationship, the bilateral relationship, but my first critique is that it's taking a unilateral focus, not a bilateral focus. The second step I would then say is, if you were to take a bilateral focus, so you were to consider the claimant and the respondent, and consider both of them, but still within the confines of the dispute resolution two-party relationship, so bilateral, not multilateral, then I think you want to ask the question, is the relationship different, and is the answer different if you're in a vertical bilateral relationship or a horizontal bilateral relationship? So here you've got a lot of cases that are coming from investment treaties and from human rights, which is a vertical relationship between sort of individuals and a state. But you've got a handful of cases where it may come up state to state, which is a horizontal relationship between two states. Now, I think there's an interesting tension, if you're going to think about both sides there, between what I would think of as the descriptive and the normative. So you get to a bit of the descriptive here, which is you say that actually these mega claims are much more likely to happen when you've got like human rights claimants or investors, because they don't have a systemic interest and they're not going to have it against them at any point. So it may well be that if you look at these horizontal and these vertical, one is private to public and the other is public to public. It may well be that descriptively, we're more likely to see enormous claims in vertical private to public situations than in horizontal public to public situations. But interestingly, normatively, it may be that it should actually be the reverse. So it may be that if you're thinking about whether a huge damages claim should go from a state to an investor, it may be that some people's instinct would be, well, that's privatizing. It's taking a private interest over a public interest. But actually, if it's state to state, it could be public interest against public interest. And so there might be different considerations there, both descriptively and normatively, and they might pull in different directions. And then let me just add the third layer to this, because I think this partly goes to your broader instincts, which is, I think there also is something multilateralist, which is when the interest is not just an interest of the two states, or of the investor and the state, but is broader for the community. So I'm just thinking of some of the very recent claims, enormous claims that are being brought about the phasing out of coal energy. And there, to me, you wouldn't want to just look bilaterally, vertically or horizontally. You wouldn't want to just look bilaterally at the effect on the given state, because there's this broader community of interest about the environment. So I guess when I think about it, I've got you do bilateral, but are you really doing bilateral or is it unilateral? Within the bilateral, what is the vertical and what is the horizontal, and what is the descriptive and what is the normative? And then is there a difference between the bilateral and the multilateral? So having stepped those three out, how does that map or differ from what you're doing?
Right. So I think that I probably already answered the first one. I think on the second one, it probably goes, I mean, I guess sort of perhaps the implicit assumption in the question is that in investor state and human rights claims, we are dealing with a vertical private-public relationship, and that is a helpful way of distinguishing or at least explaining the way how state responsibility works there. And I'm less certain that, even though plainly, I guess sort of in a down-to-earth procedural level, that is how it works, I'm not sure that the legal relationship that is being implemented is occupying a legally, juridically different plane. So I suppose really the question is about the extent to which Part 2, if we think about it in terms of 2000 ILC articles, is the same or different depending who is acting in Part 3. Yep. Or whether they sort of all flow from each other. The first part plainly operates independently of whoever the actor being injured is, So breach and attribution applies identically. The third one plainly applies differently. In the ILC context, the project was about the interstate context. In investor-state arbitration, at most, there could be something that would be applied by analogy. And part two sort of lands there in the middle. And we have the curious Article 33.2. I mean, thinking about this for some time, and I think I'm more generally inclining towards the position that Charles Leben took, I think in a way that has been almost completely missed by the Anglophone scholarship, because he did some things right in the sense that he was substantively right, but he committed the grievous error of writing in French. So who reads Annuaire Française de droit international nowadays? And I think that sort of generally, it's not something that ILC did not think about. And I think that this is something that sort of one of the things that came out of this is perhaps the slight reproach against being anachronistic, that thinking that these are new challenges, that investment arbitration throws up some entirely new angles. Well, one of the big things in the 1980s was whether, and that was Riphagen's argument, whether it was necessary to have separate rules on reparation for injury to non-actors. And Riphagen said, well, perhaps we should just really have sort of a separate rule, one thing going for the interstate setting, but injury to private actors is a totally different ballgame. And he was almost unanimously dismissed. So that was, so in a way, sort of the intellectually speaking, ILC is coming up with more of a coherent part two. We don't have a private public or public part two. There is part two, and the horizontal or vertical aspect is something that occupies part three. We are not really sort of switching on and off different legal and normative regimes. Mostly, these are things that we can articulate within them. And I think that that is sort of some of the things that are not perfectly, the tensions are not perfectly clear if we just read the final version of the commentaries, but they are clear if we read them against the background of the last 20 years of the debates. It is sort of the same rule. It may be that it is capable of taking into account some of the non-state actor elements more explicitly on its own terms. And I think if we look at restitution, even the commentaries are sort of clear that some of these will have particular traction when non-state actors or private law rights in domestic law are at issue. So I think I would probably push back a little bit at the idea that there is that distinction. Content of rules seems to me to be very similar, and I think that this is also, I think that is the way how it was conceived, and I think that that is also my general sense of how judicial and state practice has mostly treated it. So again, to go back to the triannual compilation of these materials, increasingly we see also part two coming up in all sorts of non-state actor invoked setting, not just investment arbitration, but also regional courts, and also very importantly also outside Europe. So this is not just a peculiarly litigation frenzy global north thing. I think this is really more becoming a more general thing. Now, the way how I think about the multilateral interest here is perhaps a little bit, it would have to be a slightly different multilateral interest than in the other settings that we have in the ILC articles, where multilateralism tends to add. So in the presence of a multilateral relationship, there may be more ways of involving actors that are not injured as claimants. So the Gambia and Myanmar case in the ICJ is an example, or there may be consequences for third parties that follow from a breach of some particularly important multilateral rules. Chagos advisory opinion and the follow-on General Assembly resolution as an example. So here, multilateralism would come in as a break. It would be saying that we are interested in not destroying the state and not mistreating its peoples. And in a way, that would very much go on the line of the state practice. So I think if we look at war reparation treaties from post-Second World War, people were so delightfully honest in these times, and they were saying, look, I think that was in Potsdam, so something to the effect that we don't want to starve the German people, because then we would have to provide money for them, and we have to maintain them. So it's not that we care about them, it's just that if the whole thing goes to the dogs, we would have to spend more money. And that is a multilateral interest of sorts. We have a very pragmatic realpolitik interest in maintenance of not pushing it to the full. So I think that is how I think it would be consistent with the broader thrust of there being interests apart from the two actors, so in a tort law sense, but it would come in, and I think I'm really trying to be very honest about where my claims are with the grain and where they're against the grain. On that particular thing, I think that they're slightly against the grain. Now, about the multilateral interests and the recent cases raising environmental issues, I wonder, so I think I'd really have to think it through. I'm not immediately certain that that is a multilateral argument that, as it were, if we filter it through the formal net, that it really lands at the level of secondary rules of state responsibility. And I wonder whether that is something that is more properly thought as part of the broader interpretive process, possibly application, possibly as a relevant consideration for application for particular primary rules. Because of course, I mean, I think, again, something that I'm trying to be quite honest about, these things may be also addressed at different levels. And that was ultimately Crawford's point. And, some investment arbitration, exit annulment committees have hinted that perhaps this is something that is properly addressed at the law of enforcement. And that is to some extent consistent with the broader balance struck by the ILC, where they say, okay, well, we remove the means of subsistence from compensation, but if we go to part 3, you cannot apply countermeasures in breach of fundamental human rights. And if we read to the commentaries there, we have the same means of subsistence. So perhaps sort of the point, and that is what Crawford brings out on his general part, that this is, perhaps the fact that there is no bailiff in international is a good thing. A number is just a number. These are things that we have to be addressed at the level where rubber hits the road. So I'm not just saying that it's only here, but I think my argument is perhaps would be more systemically fitting if it were here.
So I want to pick up on one thing you said, which was you're trying to be very honest about where you're with the grain and where you're against the grain. And I actually think that this was a stunningly honest piece in the space. I think you often see in international law academia a desire to not say the law is what you don't want it to be, because then you'll be quoted for it not being that. I thought you were stunningly honest here. And I also thought your analysis was spot on in many, many parts of this. But one of the things I found really interesting, and if you'll forgive me, I just want to show some images of this, because I am quite interested in the life journey of a scholar. And you and I are of a sort of similar vintage. Now, Nina's a little bit younger. We know that because she posted her age on Twitter last week. So you and I are of a relatively similar vintage, but I think we've had quite different trajectories. And so here I'm looking at the portrait of a scholar. I'm big noting both of us here by who I'm using. I'm using Picasso and Rembrandt just because I know that they do self-portraits, not because we're actually Picasso and Rembrandt. But I wanted to say that you and I met when we were young, and in some ways at that stage I think we're very, very similar international law scholars, both generalists, both with very sort of analytical and doctrinal and those sort of approaches. And one of the things I really thought when I read this, I read it kind of on one level, that you could really see the DNA signature of you as a scholar going right back to that early stage and coming out now. But I also really thought I felt some of your progression as a scholar. So I could both tell it was distinctively you, but I could also tell it was you now and not when I had first read you, which was sort of the countermeasures piece. So to give you some sense of how I think about the arc of scholars, this is something I'll apply to myself and to you so you don't feel that I'm just doing it to you. So this is how I understand you, which is I first knew you when you were the young Rembrandt, and you had extremely good technical skills, and I think your countermeasures piece has been one of the ones that I've cited the most in investment law. And I think your ability to chase things down, like every rabbit down every hole, with arguments, was both an extraordinary strength, but also sometimes like just like so pedantically going down everything that it was sort of just heavy. And this was a criticism that was made of my scholarship at the same age too. I remember somebody saying you chase every rabbit down every hole. I really felt in this piece that you had some of that same incredible skills, but there was a maturity and a lightness to like what you would touch and what you wouldn't touch, and the way in which you handled it. I really felt that you were in this middle period where you had all those technical skills, but as you see Rembrandt as he goes on, he just gets a bit looser and a little bit more just confident in himself. And I guess one of my questions reading this, because there was so much on the ILC and Crawford, and you're now sort of up for the ILC, is I guess one of my questions is, what does stage 3 of your Rembrandt self-portrait look like if we accept you're in stage 2 now? Because when you were writing this, you were also looking at like, how would you develop a rule, and it should have a clear core, but it should have some questions. And I felt like I could see you making that transition into thinking yourself into the role of an ILC representative, not because you're there yet, but I think there's a good chance you'll be there. But it felt like I could see that in that scholarly arc. And just so you don't feel self-conscious on this, I'd say I've also gone through a bit of an arc, but I'd say it's a slightly different arc. I think mine's a little bit more Picasso-esque, where I started out with more doctrinal approaches. It became more abstract, and I think in my later stages it might become scarily abstract. We're still waiting to see. But I wanted to say, with this sort of image of your intellectual arc, how do you see yourself moving through it, and where do you go next?
Well, that is an extraordinarily kind way of framing, and so complimentary, so very kind. I think I was probably more usually thinking about such things as a cautionary story, you know, like Caravaggio, you know, whatever don't get stabbed in an Italian harbor. Yes, so I suppose I think I certainly would like to think that that I suppose the technical ability and the generalist analytical perspective is there. I suppose, and I think that is something that has perhaps of an instinct that was, let me just say, to be very clear, that when I wrote the piece, it was not at all as a campaign piece for the ILC. I did not know that I would be nominated for that point. So in a way, it's just sort of a little bit of a fortuitous coincidence that I was thinking about it. Sort of perhaps I suppose in some sense, the basic truth of the formalist legal process, I think that is what Crawford did in his general course, that, you know, whatever the imperfections of international law as a universalist system is, it's less imperfect, less horridly inaccurate, less unjust than anything else that could be conceived of the matter. And really combining, on the other hand, the appreciation of, I suppose, really the basic truth of the formalist legal process, at the same time also, I think, appreciating really sort of the other side of the story that could be told, the extent to which ability of actors to allocate resources to their legal skills to some extent shapes the legal process. Perhaps there's some sort of, you know, I think really rather explicit blindness of international law to some things. International law will reward competence. It doesn't really care majorly why you're competent, why are you able to have a legal bureau that is consistent on a particular issue for the last century or not. So that, I think, is really the thing that I'm sort of struggling with, and I think you're right. I think that is where a little bit of a tension of taking the square and the whole and playing with it comes from. I'll certainly think about the third picture going forward.
I'll pass to Nina now.
Fantastic. Thank you so much. So we are at 6, but I didn't want to interrupt, the portrait of the international lawyer as a young man. So if that's okay with both of you, I might take 1 or 2 questions from the audience, if it's okay, because we have had a really big audience who has asked some wonderful questions. And they're taking us back to your paper, Martin. So Clara Maria is thanking you for the paper and for the brilliant presentation. And she's asking whether the fact that promotion of development is, promoting economic development is the purpose, or is the stated purpose of BITs and FTAs, to the extent that it is embedded in the instrument, it could also serve as an argument against crippling compensation.
So I think that there is, again, well, many thanks for the question. And I think there's, I suppose, a slightly more formalist and a slightly more realist angle to that. And I guess probably slightly more formalistically, we would probably have to, it would probably be easier to locate that argument somewhere earlier in the reasoning process. And of course, in a sense, I'm sort of taken as a given that the loss has arisen and has been evaluated. And these seem to be more things that properly pertain to the question of primary obligations and primary rules. If to locate it at my level, one would probably have to say that there is, and I think it's sort of, I wonder whether perhaps Anthea would be slightly more sympathetic to that angle, that that there is, a particular legal relationship with a particular dynamic and particular purpose, which might suggest a different secondary rule on the issue. That's something that would take these matters into account. I mean, there has been something to that. I mean, I think that is what Brownlee said in his separate opinion in CME and Czech Republic. I think it's, if I say, I suppose, a side note on the ILC and the importance of taking it seriously, the one thing that distressed me to no extent was that Brownlee, who was one of the great scholars, of course, on war reparation and their limitations, was present during the discussion. I did not say anything at all. So I think if there's one thing that I can promise, that if I'm elected, if somebody mentions something that I have written on, I will certainly peep up on that. So I think that would be my my slight skepticism, and I think still that I would, perhaps just undernote how important the conduct of parties is in shaping it, and I appreciate that this is much, I think, really sort of requires a much sort of, it's easier to Control F a particular term in the section on analysis and derive it from that. But I think sort of the more we read carefully, I think the more we appreciate, particularly in arbitral setting, and by we I mean myself, how much the shaping, I guess, really shared professional consensus on a particular issue affects it. If nobody raises something, it's something that is considered to be too trivial, too silly to raise. I think it is, again, it provides a broader professional grain against the background of which tribunals would act. So I think that is something that would make me both, I suppose, legally and normatively a little bit cautious on that.
Thank you very much. Anthea, do you have anything to add?
Let me just say one thing on the end, which is one of the other things I think is a real signature from Martin's, if you look across his papers, is not just that analytical approach, but a very strong commitment to the doctrine. But then often you'll see he does a finger pointing to the future with normativity. And you see it across a number of his papers where this is sort of something that happens. And it's just, I feel it also happens in that last question. So I just, in terms of the scholarly signature, I feel like I could tell this one was Martin's without it, if I was peer reviewing it and I didn't know it was Martin's.
Excellent, thank you. If anyone ever tries to counterfeit an article, we will know how to figure it out. On that note, I want to thank you both very, very much. Also because both of you agreed to do that on slightly difficult times of the day for both of you. I want to thank the audience. I want to also ask for forgiveness for those who have asked questions, but I didn't ask them out loud. They were wonderful questions, but we're already running over time. I want to thank Martins very much for this fantastic paper, which I have posted the link in the chat. And I want to thank Anthea for the very well thought through comments and for the reflections, both on the substance, but also on the scholarly craft, right? What it means to be an evolving international lawyer. And on that note, I'll thank everyone. I'll remind everyone that the next seminar is taking place on the 14th of May with Professor Sarah Seck and Dr. Cassandra Steer. And I would like you to join us then, but also for now, I would like you to join me in thanking the two wonderful presenters. Thank you very much.